Welcome to the CMMC Proof Podcast. I'm your host, Derek Phillips, a certified CMMC assessor and provisional instructor. I am thrilled today because I have Reneé Brooker joining us. She is a partner at the Washington, D.C. law firm, Tico and Zavari, and she's also a former assistant director for the civil frauds at the United States Department of Justice. She has a really impressive resume, so I'm going to let her also go in a little more detail about her extensive resume. But welcome, Reneé.
Hi, thanks for having me, Derek. Really, I'm excited to be here to talk about False Claims Act and other whistleblower reward programs.
Whistleblowers, yes. It's a topic that gets people attention whenever you hear about it.
And it should.
Yeah, it should.
Yeah.
It definitely should. So can you tell us a little more about your experience?
Sure. I have spent pretty much my whole career, the way I sort of frame it is fighting fraud on behalf of taxpayers. So I have worked in just about every industry space that you can imagine, because almost every industry, if not every industry, does business either directly or indirectly with the federal or state governments, whether it's through direct grants or contracts or credits, say in the environmental industry and other industries where you might reduce payments that you need to make to the government. So pretty much every industry touches the space that I work in, and everything from initially when I started out, I was fighting fraud in the federal financial student assistance programs. A lot of for-profit school fraud, which still happens today in the student space, everything from financial industry to government contracting to higher education. As I said, healthcare space is really big. And right now, cybersecurity, cuts across all of those industries, because we all have our information, sensitive government information, as well as protected information of consumers and patients, students in electronic form. And so cybersecurity is the number one priority for the current presidential administration, and certainly for the Department of Justice, which is why we're here to talk about it today.
Oh yeah, a lot to talk about. Before we deep dive into all of the details, what do you like to do for fun outside of the law?
Well, I'm a podcast junkie.
Really? I don't.
So
Awesome.
Yeah, and anything that has to do with a crime or scandal, okay, I like listening to. So there's a lot of podcasts. Everybody has a podcast now, right?
Right.
I mean, even CNN, big news agencies, and like yourself, because most of us are on the go. We're walking, we're running, we're in a car, and that's kind of how we need to get our news and information when we're all busy people. So yeah, it's my downtime. It has to have crime or scandal involved, though.
Even when you're downtime, you don't get away from the law or fraud.
That's true. You're right. I think I am just kind of naturally attracted to, and find interesting that space. So yeah, good point.
Awesome. Now, as far as cybersecurity fraud that we talked about, and typically when I first learned about the False Claims Act, I more so heard about it in the context of cybersecurity, non-compliance, and it's really going to pique our audience interest. Can you talk more to us as far as we know the Department of Defense and with CMMC, that gets a lot of attention, but a little more details into who should be concerned about cybersecurity compliance and what are the actions that the government can take to identify essentially fraud from a compliance standpoint?
Yeah, it's a really good point of discussion. It's a broad topic. And so the government, and when I say the government, I mean the federal and state governments and local governments, frankly.
Okay.
Any taxpayer funded program or any taxpayer pot of money, let's say, the government, which means all of us taxpayers, we pay for goods and services in, as I mentioned, just about every industry. So anytime that the government and we taxpayers are laying out money for goods or services, directly or indirectly, we are entitled to not be defrauded, right? And if someone dupes us, we want our money back. We want the important government program or grant or contract to be free of fraud. And and if there is fraud, and there's plenty of it, unfortunately, there's bad apples in every industry or actors that really don't care, that give short shrift to what they're doing with the taxpayer money. Then we want a mechanism to recover our misspent dollars, and also to deter the same company from doing it again, and from others in the same industry from repeating the behavior of the company. So that's why you have the False Claims Act. But it's not really just the False Claims Act, because other agencies are now on board with really paying attention to the importance of good cybersecurity practices. And so there are other whistleblower reward programs that are quite sizable. The Securities and Exchange Commission and the CFTC, which regulates commodities, they also have their own cybersecurity initiative, and they also are seeking to reward whistleblowers for stepping up and for reporting known failures of cybersecurity protections in the financial industry, for example, and for making material false statements to investors and to consumers about the types of cyber security that maybe your local bank where you do banking, what kinds of protections they have in place. So ensuring cybersecurity and ensuring that the government is getting what it pays for, which is that data of individuals in their systems are being confidential and protected, and they don't end up on the dark web, right? And that they are doing everything in their power to ensure that that happens. And when a financial institution or a government contractor or grantee gives short shrift to cybersecurity protections and knows that they are, because they have other things they'd rather be spending their time or money and resources on, then that could very well lead to an enforcement action by any one of those agencies. And if a whistleblower steps up and reports that this is happening, then they have a financial incentive to do so. And depending on how good their information is, they may be entitled to a financial reward.
Okay, makes a lot of sense. So to put that in context, let's say a federal contractor, they just signed a contract with the federal government. How do they even know what their cybersecurity requirements are?
Well, if they're a government contractor, believe me, they know. They are in a highly regulated industry. They are getting money from the government, and the government, like any other customer, expects that they are going to get what they paid for. And if they don't get what they paid for, they're going to want their money back, and they're going to want a penalty, which they're entitled to under the False Claims Act and other statutes. For example, if you're a government contractor, of course, depending on, and I know you know this because I've listened to some of your excellent other podcasts and you're learned in this space as well. And just like you probably don't even have a government contract and you're learned in this space. So the contractors are very sophisticated players, and they know they are subject to, for example, cybersecurity requirements under the Federal Acquisition Regulation, right? And under DFARS, which is the Defense Federal Acquisition Regulation Supplement for contracts specifically with DOJ. There are other agency specific regulations too that contractors know they need to comply with, such as FedRAMP, which folks in the space are very familiar with. It's the Federal Risk and Authorization Management Program, right? And NIST, which is the National Institute of Standards and Technology. It's a federal agency that sets standards for several industries, including the best practices for cybersecurity protection. So these are all independent and overlapping requirements, statutory and regulatory, that really lead to a robust oversight and set of standards that are required of government contractors. One way that a case is developed against a federal contractor or grantee is to look to what they have internally as written policies and practices, because in all of our cases, they know exactly what those requirements are. They have extensive written policies, but they're not implementing them in practice, right? So it is one way to be able to tell how they do. They're very aware of it.
Right.
They're very aware of all the requirements, and it's a robust regulatory.
Yeah, it sounds like there's no shortage of regulations what they need to do. Like you say, they're overlapping. And that's one thing when we're advising clients that we always tell them, don't write anything in your policies that you're not going to do, because it sounds like
you just nailed it. That's it. That's
come back to bite you.
Because that's what they do. They know what they're supposed to do. And they just decide not to do it for any number of reasons. Sometimes we see in some of our cybersecurity cases, but it's not really just cybersecurity, but in particular, since we're talking about that topic, where a government contractor, most of them have commercial business and government contracting business. And so they will have phenomenal protections in place for their commercial business, but they will, again, give short shrift to their government contracts customers. We see that they know how to do a good cybersecurity. They're just choosing to put all their resources and time and all those eggs in the basket of the commercial customer, and just decide that, well, I can defraud the taxpayer funded program a lot easier than I can a commercial customer, which is going to be very demanding of me and not so trustworthy. And we see that, and that's very good internal evidence that the company knows exactly what it's doing, and it's choosing to avoid making good on the government contract promises and requirements.
Awesome. Can you give us some insight into what goes in the process of that investigation? Once the DOJ is notified by a whistleblower, what does that investigation look like?
As you know, because you've been talking about it on your podcast, DOJ fairly recently, really the last year and a half, 2 years, has decided, along with the current administration, to put a high priority on enforcement under the False Claims Act of cybersecurity violations. So they made a call to whistleblowers, and we can talk about what does that mean. I know people ask me in my personal life all the time, what's a whistleblower? Am I one? Could I be one if I raise my hand? So employees and other individuals with knowledge of fraud, they made a large sweeping call to the universe of individuals who might have specified good knowledge of cybersecurity violations to step up and to report it. And they were looking for certain types of violations. And again, the government wants anybody they've provided money to through a government funded program to make good on their promises. So once you file a case and it's a secret lawsuit, it's filed under seal without the identity of the whistleblower known to the defendant. The DOJ will work with the team. Now, of course, I used to be a DOJ. Now I'm representing the private whistleblower. So it's considered a public-private partnership. You will work hand in hand with the Department of Justice prosecutors under their direction to provide all of the information that you have and to assist them during the investigation when they are consulting with the company counsel, seeking documents and information. You and the whistleblower, your team, as the counsel, will help the government with knowing if the company is being forthcoming during the investigation because you're the whistleblower. And so you can have a lot of insight into what the company is telling the DOJ. As a practical matter, what will happen is once we file our under seal lawsuit, the prosecutor team, and they'll amass a team. So if it's a DOD contract, they'll have somebody from DOD who will work on the team. It might be someone from the Office of General Counsel. It might be an agent or two agents who are assigned to the case to help the main prosecutor investigate the case. If there are multiple agencies involved, because a lot of these contractors have contracts with multiple agencies, not just one. They might have contracts with DOD, they might have contracts with the Department of Energy, they might have contracts with the Department of Education. You might get a team together, if you're the prosecutor, of agents and attorneys from the Department of Education on your team. Department of Energy will help on your team as the government team. Wow. The first thing that the government prosecutor does is, who's my team, who can help me, who has expertise, who has time to work, and who's interested in working on a case that's been brought to me by a whistleblower. So that whole team will sit down with the whistleblower and their counsel and have an all-day dialogue in some instances. In the initial look at all the documents the whistleblower has gathered, we'll put together a PowerPoint presentation for the government so that us and the whistleblower can walk the government through the allegations and the evidence and the concerns and our liability theories and all that good stuff. And then the government will issue a subpoena to either the contractor, the grantee, whatever the entity is that is now under investigation. The whistleblower and their lawyer will help with that subpoena because obviously it's our team that knows what do they call documents internally at this company, because companies all have different nomenclature. They all have different types of documents. Some have Slack for communication, some have Teams for communication, some use only email. And so the whistleblower will say, you want to get, this is the thread. This is the title of the thread. That's where they're going to talk about cybersecurity vulnerabilities. So it's like a public-private partnership where the whistleblower and their lawyer are helping guide the government where to look for more evidence of the cybersecurity violations. And a lot of times the prosecutor team will take depositions of employees who are currently at the company who are in key positions. They might depose the head of cybersecurity. Your whistleblower might be the head of cybersecurity. So, and sometimes your whistleblower, a lot of my clients stay at their company after they file the complaint and during the course of the investigation. So those are tricky things that a lawyer
it could be a little awkward.
Yeah. Well, for most of the investigation, the company doesn't know who the whistleblower is. And so they'll get big law counsel and they'll help. That lawyer team will help the defense, the government contractor or the defendant wend its way through the whole process, because in this space, most of these government contractors are getting very experienced big law counsel, just like myself. My friends who used to work at DOJ with me, they are now working on the other side of the aisle, and they're very capable lawyers that represent government contractors and grantees in these types of investigations. And so, everybody will have their attorney, helping them through the process. And that's sort of how it will go. There will be an investigation, and there will be constant dialogue among attorneys. The counsel for the government contractor or grantee will be constantly interacting with the prosecutor, as will we. We won't all be in the same room together. We'll all be having, separate conversations primarily until the end of the case is resolved. But there'll be a lot of conversations and a lot of questions asked by the prosecutors, because they're trying to get at the truth. They're trying to uncover what happened here. They're trying to corroborate and validate the whistleblower's concerns. And eventually there will be a resolution. And the resolution can be, as you can imagine, any number of things. The government can say, we really took a deep dive, looked at your allegations. We appreciate your concerns, but we don't think we can make out a case to bring against the contractor because, and there could be any number of reasons. Recently, we were told everything the whistleblower told us was accurate, and there's lots of evidence of fraud, but there was actually, the company wasn't very successful at its fraud, so it didn't make any money off of the fraud. And so there's nothing for us to recover. That's kind of an unusual example, but sometimes the government can't meet a certain element or burden of proof, and so the case will just be closed. Other times, and if you have a good whistleblower, it's going to probably result in a resolution, because they're going to have brought the government some really good information. And with good counsel, they will have properly evaluated those claims and determined, that they are meritorious. So, but and there are other times where the government says, look, your team is very qualified. Why don't you litigate this case? So sometimes the whistleblower team will litigate the case and continue on with the discovery and get involved in the litigation. There are many, just as you can imagine, kind of like no different than any other crime, any other street crime. You have to conduct an investigation. You have to see who your witnesses are. Do you have strong evidence? Can you meet your burden? And in this case, it's a little bit different in that it's a really rare statute where the whistleblower team can be given the rights to handle the litigation. And so it adds a lot of resources and value add to the government team and the government in being able to fight fraud, frankly, because they have a whole cadre of private counsel and private whistleblowers who can, really, really help move cases forward.
Right. And I know the Aerojet Rocketdyne case that was ultimately settled is an
Yes.
example of that, where the DOJ decided not to intervene
Yes.
or attach to that case, but the relator and his attorney decided to move forward, and then
Yes.
there was ultimately a settlement.
Exactly.
Now, the investigation process that you just outlined, does that typically happen before the DOJ makes a decision to intervene or not?
Yes. All that
Oh, okay.
happens
I didn't
before.
understand that. Okay.
Yeah, so
So,
some of these cases take years for the government to investigate before it gets to the end result. Partly because these are complex cases, and when I say complex, not necessarily complex legal theories all the time, but it's a big contractor, right? Typically, and there's a lot of documents, and there's a lot of people to talk to, and government just wants to be sure that they're going after the bad apples. They don't want to go after companies that are trying their best and just not getting it right. So they want to make sure that they've gathered all the evidence before they take the final step of getting in, what's called intervention authority to sue the company. And a lot of these cases end up that investigation ends and the company says, let's come to the table. We got problems here. We fully acknowledge that. We want to settle this case. You don't need to sue us. Let's talk about a resolution. And a resolution, always involves the payment of money and some what's called a multiplier, more than the damages that were done, in order to deter future misconduct. And sometimes an administrative component will happen. Sometimes if it's a government contractor, they will be suspended for a time, or they'll be under some sort of like an independent oversight body, because it was clear to the government agency, like, you can't be trusted to be on your own for a while. So we're going to put in place some sort of conditions on you, as well as you're going to have to pay us back, and you're going to have to pay a multiplier, because you can't just pay us back. We just spent all this time and resources investigating the fraud allegations. So you owe us more than, you took. Owe us more. So there are a whole bunch of different ways that justice can be done. And it's a very good public-private partnership, and it's a good process, and one that I think everyone can have a lot of confidence in.
When it comes to cybersecurity noncompliance for FCAs, have you typically seen where once the DOJ decides to intervene, that kind of incentivizes the defendant to settle quickly?
Yeah, I mean, it does. The vast majority of cases settle before the DOJ goes and starts the lawsuit. So they do their investigation, and then they typically make a presentation of their own to defendants and their counsel. Typically, it's a PowerPoint presentation. It's like, as you know, you've been producing documents to us for 2 years. We talked to half of your employees, and here's the findings. Here's what we have uncovered. And here's how we see the fraud. You're going to have a different view because everybody has a defense all the time. No one's ever like, oh my God, you got me across the board, right? I did everything you said. There's always going to be a give and take, but the government's going to say, hear me out. This is what we think is your liability. This is what you owe us. What say, defendant? And most of the cases end up settling at that point. But those that don't, sometimes that people just don't see eye to eye. And the contractor says, no, I'm going to fight you on this. You're going to have to take me all the way to court, right? Some people are litigious. As I always like to joke, some are lovers and some are fighters, right?
Yeah.
Some of them come clean. I've seen it all as a prosecutor. I've seen companies that are very forthcoming with the government, and they say, you're right, you nailed it. Like, we have problems here. We see that we have problems. We want to make good on our promises, and we want to negotiate how much we have to pay. Right. So we're not going to pay what you want us to, but we'll talk negotiations. Other companies are like, hell's no. No. We disagree with you, or we're litigious. We got nothing to lose, so we're going to fight you on this. But I will say, even in those circumstances, like 99% of cases settle after that next phase of litigation. Before very few defendants, government contractors or grantees or anyone as a False Claims Act defendant, very few of them go all the way through to trial and let a jury decide. It happens, but not very often, because they know that the agency could impose some pretty severe penalties on them in addition to the money that they would have to pay. They could suspend or debar them, for example. And some types of actions are mandatory suspension or debarment. So most of the time, after people do get out long enough, there is a resolution. And it might look different than the one that occurred if it had occurred 3 years prior. So sometimes people would have gotten a better deal. In my experience, you get a better deal if you come clean early and you fess up. Others obviously aren't going to agree with me on that. They're going to say, no, I'm going to put the government through its paces and make them prove their fraud.
Got it. I know during your time at the DOJ, you had a pretty successful track record, recovering over $6 billion in recoveries. That's a lot of money.
A lot of team members, agencies working on cases with me, and lots of great public-private partnerships. So nobody does anything all by themselves. But yes, False Claims Act recoveries are in the billions of dollars annually. So it is literally the government's number one enforcement tool in the government contracting space, since we're talking about government contracting here. But across the board for fraud, there's nothing like it, because it's how the government recovers misspent program money, contract money, grant money. Medicare fraud is by far and away the biggest use of the False Claims Act.
Fraud.
Right for fraud, exactly. A lot of recoveries are had in the Medicare space by using the False Claims Act. But I actually don't want to give short shrift to the other whistleblower reward programs. Because when we have a whistleblower who comes to my team, and my firm has a cybersecurity team, we specialize in cybersecurity cases. When a whistleblower comes to us with any kind of cybersecurity, healthcare fraud, government contracting fraud of any variety, whatever the fraud is, we evaluate their case for all the whistleblower reward programs. And sometimes we file under more than one. So especially in the cybersecurity space, this is a very unique place to be, because a lot of cybersecurity violations are both False Claims Act violations and violations of securities law or commodities law, or all three. So, for example, if you are a big publicly traded government contractor and you are making SEC regular filings, you're reporting your annual reports to investors, and if you open up anybody's filings, you're going to see a section on cybersecurity. And if they're bragging like, we have the best cybersecurity known to man, man, we've got all the controls in place. We have no incidents for the last 3 years. You have a whistleblower who tells you, wait a minute, I'm the head of cybersecurity and we have no controls in place. We have significant problems across the board. We have numerous incidents and they remain open. Like I have a lot of whistleblowers who come to me with cases where there are incidents and breaches and they're still open. They've never been addressed, remediated, closed, report it to anybody, consumers, the government, no one. And in those cases, if it's a publicly traded company and they're making public statements on their website and their SEC filings and their reports to shareholders, like we have an amazing cybersecurity program, we have engaged in best practices, that right there is very possibly a cause to file a whistleblower case with the SEC and with the CFTC if there are commodities involved, and under the False Claims Act if they're a government contractor and these failures are related to their government contract. So we do have a number of cases on my team where we have filed with all the agencies and all the agencies investigate at once. So the team is even bigger than what I said, right? It's not just a prosecutor at DOJ. It's now a prosecutor at the Securities and Exchange Commission, and they call themselves enforcement lawyers, and an enforcement lawyer at the CFTC, and they're moving in lockstep on an investigation. And they all issue their own subpoenas. A big publicly traded company might be hit with multiple subpoenas with the same whistleblower.
Wow. Yes. Pretty intimidating. The all-star team. Wow. We haven't talked yet specifically about the civil cyber fraud initiative. Is that the announcement you're referring to, or the DOJ pretty much, okay, let the whistleblowers know?
And the CFTC also have initiatives that they've announced around the same time. So they've really ramped up their enforcement efforts to weed out cybersecurity failures that are known and unabated.
So in the context of federal contractors, say it's a small business, they have that FAR clause in their contract, but the defense they're going to put up and say, hey, I didn't understand the clause, I didn't understand the requirements. Is that a legitimate defense?
Well, so what's going to happen is, first of all, our whistleblower, we'll be evaluating that case. The whistleblower will have, we'll put on our prosecutor hat when the whistleblower comes to us and we'll ask all the same good questions we did as prosecutors, and we'll see if they have evidence. Some of them have extensive documentary evidence, others have less. And the devil's in the details, right? We turn away whistleblowers just like we retain them and file cases. We never want to have some poor individual file a case that is dead on arrival and then they have that hanging over their head. So we really do care about the client. We don't want to just file for file. We want to file something that's going to get traction and investigation. So right off the bat, what the government is going to be looking for with that kind of a defense, and frankly, Derek, you're not wrong, because big, medium-sized and big contractors have that defense. They say the same thing. So the types of things, everybody says it. So it's kind of a but maybe there's more legitimacy as you're pointing out to a small business. Maybe it may be that very well may be more legitimacy to a small business. The subpoena will go out. The types of documents that small business will have to produce will be: were you keeping logs? Like a really basic thing that you better have been doing. Have you been keeping logs of events? Turn over those logs to me. Let me see how you handled, addressed, were made aware of incidents occurring based on those logs. Also, small business, have you had any audits performed in this realm? Anything relating to cyber security? If you had an audit, we want to see that. How did you react to that audit? So everyone has audits, and everybody has bad audit findings. That's the point of audits, is to find your flaws. Their audits aren't supposed to be all glossy. If they are, your auditor probably isn't doing a good job.
Suspicious.
If you audit my financial statements, they're going to be like, your tutor's wrong, Renee, on your math. Like that's what you're hired for. So we do expect, when you're at the government, and we expect you're going to have audit findings, and that's okay. That's not a ding against you. But has that same audit finding saying that you are not paying attention and drilling down on cybersecurity, say, attacks, each year, 3 years in a row, you've had that same audit finding and you've done nothing about it? That is a possible strong evidence in a False Claims Act case, because you were told by your auditor, every year you have this problem. There are hacks on your system. They're getting in. And if you're like, oh, okay, well, what do I do about that one hack that happened? But you do nothing at all to change any of your practices, then that could be strong evidence. Not you have one finding, you make a remedy, you remedy it, not a False Claims Act. You have the same finding over and over again, that's strong evidence. It's not all the evidence, but that's strong evidence. But the government's going to look for audits that you've taken, logs, and they're going to, just like you said, Derek, earlier, you nailed it. What do you say in writing about what you know you need to do. Let me see your
Okay.
written policies. And sometimes, a small business or a defendant will say, see these written policies, I'm all good. I told you, we have them. And we're like, well, that's what you say in writing. But
Right.
are you following your policies? Because if you're not, then that's good evidence that you're violating the False Claims Act. Not That's not helpful
Knowingly.
to you. That's helpful to
Yeah.
the prosecutor, right? We also
Right.
want to see when you're on the prosecution team or on the relator team, like our big team, what we also want to see are internal communications related to your cybersecurity, whoever would be talking about it. In a smaller organization, it might be one guy, right? It might just be the IT guy. If it's a
Right.
really small, they don't even have like a cyber professional. They just have an IT guy. However, I will tell you, Derek, having dealt with a lot of small contractors, they often have massive government contracts and they have responsibility for like huge swaths of sensitive government data or patient data or student loan data. And they're still a small government contractor. Sometimes they bring
Okay.
in subs that are bigger. And so they have to have good, practices in place. So you want to kind of look at the smaller contractor. What kinds of sensitive government data are you housing? Because is it sensitive or is it not really sensitive? So maybe that's like a way to mitigate. Maybe, you're not doing a great job, but you had no audit findings and you're small. Your IT guy is just not experienced and you don't have that many problems. You just have some, but you don't have that much sensitive government data that you're dealing with. I don't know. Maybe you're a painter contractor for the government, right? That's what you do. You paint all the buildings or something like that. You don't have any sensitive government data. So, you're going to have to look at those kinds of details. So just being small is not a defense, right? It really,
Okay.
like, the devil's in the details. What are you housing? Is it sensitive data? And whose sensitive data is it? Is it veterans? Because sometimes there are VA contracts for veterans healthcare. Is it veterans data? Is it government sensitive data? That's what you're really looking at, not so much the size of the contractor. And you're
Okay.
going to ask for communications with the person who's responsible. And sometimes the person who's in charge, like yourself, Derek, someone who has your expertise, is the one raising their hand inside the company being like, yo,
Right.
over here, like, we can't keep doing what
Help.
we're doing. And
Yeah.
and they're like, oh, well, don't listen to Derek because he's not our core business. He's just, our cyber guy. And, we don't
Right.
want to spend
Yeah.
money. Derek wants us to spend all this money to protect
Yeah.
this government data. We're not going to spend the money Derek wants us to spend. We're not going to do it. So
Right.
we always have to take a look, the devil's in the details on any set.
Yeah, makes sense. And that's something you referenced earlier, where the leadership for the organization decides not to spend the money, allocate those funds to cybersecurity. That's not a defense. Absolutely. We know with some of the recent high-profile cybersecurity FCA cases, like Penn State and Georgia Tech, which was recently unsealed. So the DOJ did decide to intervene on the Georgia Tech complaint. So does that mean that the DOJ has already really completed their investigation at this point? Now they're building that PowerPoint or
Yes.
preparing their
Well,
report? Okay.
So
Okay.
what that means is they have completed their investigation. In all likelihood, they had tried to settle with the defendant, in all likelihood, because
Oh,
generally speaking, as a matter of general policy and practice, the Department of Justice always gives a company under investigation the opportunity to settle before suing them. So in all likelihood, those negotiations did not take place and they decided we're going to move forward. But now discovery, like in the typical litigation sense, will begin. So
okay.
both sides will serve discovery on the others. Georgia Tech defendants will serve discovery on whatever government contracts are at issue. They'll serve discovery on the DOD. They'll seek to depose a government contracting officer, right, on those Georgia Tech contracts. And meanwhile, the government will continue to get information by way of depositions and subpoena from Georgia Tech. And the DOJ hasn't even laid down its complaint yet. That still has to happen. So they
Right.
don't just adopt whole cloth what the whistleblower said because they have done an investigation. They're either going to have a narrower complaint than what the whistleblower alleged or a broader one, or just they've uncovered more facts than the whistleblower had in their possession, so they'll add to the complaint. So it'll just be a new complaint, and then litigation will proceed with motions practice, more discovery. It could last for a couple more years.
I work with a lot of people in the higher ed space, especially that are on the front lines of trying to secure those research universities, and they feel as if the higher ed is being targeted. You think
Oh,
it's more
yeah.
so just a coincidence where some of these high
Coincidence.
profile coincidence? Okay.
It is. Yeah.
Yeah.
And really, you can only look at the Georgia Tech one. And that was just a fast prosecutor that moved quickly. But the Penn State one has nothing to do with the DOJ or the whistle. It has everything to do with the judge. So my understanding is the judge who had that case does not ever let the government investigate for very long. So the judge lifted the seal off of the law of the, so it really kind of cut short everything and said, nope, some judges are very impatient with long government investigations that are under seal.
Okay.
This judge was, and this judge said, nope, not letting you have more time. You had enough time. And it was short. I don't remember what it was. Wasn't it like 3 or 6 months? Some short period of time, which is very hard to do an investigation. But the problem is when a federal judge does that, all these consequences fall into place. So DOJ is internally, I'm sure, saying, but we're not done with our investigation. We don't know if we think this is a good case. We're just getting started. So it'll be this odd posture that doesn't happen that often and shouldn't happen that often, but where the government's going to continue its investigation and the whistleblower is going to have to go ahead and litigate. And maybe the DOJ, once it's concluded its investigation, maybe it'll decide we're not going to get involved, and maybe it'll do exactly what is happening in Georgia Tech. Maybe it'll intervene and it'll make a bigger complaint, a smaller complaint. It's hard to say, but those are just totally coincidental. You can only really look at Georgia Tech because that one normally would have been under seal and still being investigated and determined for a longer period of time. But
Okay.
no, I mean, the higher education field shouldn't feel like, they're being targeted. They're not being targeted. It's really anybody who's not really using best practices in the cyberspace, and they're getting the money from the government, and the government expects to get what it's paid.
Okay. Yeah, makes sense. That's a lot of great insight from the prosecutors. Your point, I really appreciate it. I do want to probably have another 100 questions related to that, but I want to pivot and give you some opportunity to talk more about your private practice and what was your inspiration to leave the DOJ and move into private practice to represent whistleblowers, and what's that experience been like now that you're on the other side?
I mean, really, I have loved it all. I love what I do. I love the False Claims Act, and I love getting money back for defrauded programs. They're important to me because all these programs are important, and taxpayer money is precious, right? It's not unlimited. And I pretty much, for me, I wake up every day motivated by, taxpayer and these important programs. Like these government contracts are very important government contracts. I mean, the government pays for everything from satellites to warfare to big jets being built for the military, everything, right? The government does almost nothing anymore. They contract out for eating their cereal in the morning.
Yeah.
These are important issues and important contracts. It's not just about money because it impacts real people's lives. Releasing sensitive government data to the dark web is no joke. In the cyberspace, I'm very interested in this area, and DOJ is. This is kind of how I want to spend my time. But I will say that it's always been a public-private partnership. I just used to be on the public side of the partnership. Now I'm on the private side of the partnership. Yeah. But I will say, working with whistleblowers in a more intimate way than I had done when I was at the Department of Justice is something that I enjoy very much. When you're at DOJ, you're focused more on the attorney who's representing the whistleblower. You're interfacing with them more than you are the whistleblower, who's a little bit more behind their lawyer because they have an attorney. One thing that I've been super impressed with is meeting all these individuals who are trying to do the right thing. They have a lot of integrity and belief in the system. So when they see something that they think is wrong, they report it. And the other interesting thing, Derek, is a lot of people, more than people realize, a lot of people come to my doorstep. They find their way on my doorstep because they've called an attorney, and their question to that attorney was, things are happening at my company and I'm worried about my license. Whether they're a nurse, an accountant, CIO,
Yeah.
It doesn't matter. There is bad stuff happening here where I work, and it's fraud, and I'm in the middle of it. I see it. So I can't just sit by and do nothing and my fill in the blank, whether it's their license or certification or whatever. Right. It's at stake, as well as they appreciate that they're always victims to everything. It's not just the government program that's a victim, because all these government programs are all about people. Right? They're providing a service to individuals, or in the case of cybersecurity, they are protecting sensitive government data and sensitive data of individuals. And the individuals who step up are usually in the thick of it. And that's how the conversation begins. Not everyone knows what a key tam is, right? So most people don't show up on my doorstep. Now, there are some sophisticated people who do. They're like, I've been Googling because I have these concerns and I've heard of a key tam and I showed up on your doorstep. But most whistleblowers show up on my doorstep because someone has brought them to me who somehow knows me, and they say, what you're telling me, I can't help you, but I think you might need to talk to Renee, who's a whistleblower lawyer. She can tell you if you have a whistleblower claim. So, that's what I really enjoy about being in the private side now, is that I get, in the first instance, I talk to tons and tons of people. It's part of really what I do every day. Is I talk to like 1,000 individuals who call me, email me directly, and I try to evaluate their case and tell them right off of the bat, you're someone that we should talk to more over time and try to develop a case. Or other people where I say, appreciate your stepping up and trying to do the right thing, but you don't have a False Claims Act case here, and try to direct them somewhere else. But I know our team, I have an excellent team at this firm. My partner is also from DOJ, and her name is Eva, and she was the senior counsel for healthcare fraud and also did a lot of government contracting, government procurement fraud. And we have, and two of our other team members they're much more junior, but they've been doing this False Claims Act representing whistleblowers since they've started their careers as well. And so we have an excellent tight team. And I love working in this space. It's always interesting. Feel like we're doing the right thing. And I feel like we represent a good screen for filing the right cases and avoiding filing bad cases. And I think I mentioned to you earlier, on behalf of the individual, I don't want to file a case that I know is not meritorious and that will be dead on arrival at the DOJ and have them put their name out there when they really shouldn't have their name out there. So I think it's important at the initial stage when they come in to make sure that they have a good claim and not just file something to file something.
Understood. Yeah. I'm just talking to you. It's clear that you have a heart for service and you're really passionate about protecting those whistleblowers and also the government from fraud. Now, can you give us a high-level overview of what that first phase looks like when someone contacts you as a whistleblower and they have those concerns? What's the type of question should they expect? What type of evidence should they potentially be prepared to gather?
First, I love to Zoom with people. I want to see you and I want you to see me. And it's a conversation, right? My partner and I start off every call asking the person, like, what are your concerns? So share, because most people who call, they don't know. They don't know how to talk the talk, right? They're not going to tell me, I have a materially false claim.
That would be suspicious.
And evidence of the enter. So I want to know what their concerns are. And then I want to dig deeper. Our team will get involved right away if I'm hearing certain things. But one of the things right away, there has to be some government funding and program that is at stake, right? That's one thing. And sometimes people come to me and they don't even know that is the case. So, and this is a great example in the cyber world. We have a very good case under investigation. And when the whistleblower first came to us, and he really was brought to me by someone else, and he did not know whether these violations were impacting commercial or government contracting business right away. So we had to dig into that a little bit more. And we uncovered that actually the problems were unique to the government contracting side of the company. The commercial business, they were doing great on their cybersecurity. So it just really required more digging, more of a conversation. And the ideal whistleblower, Derek, this is the one piece of advice I give to folks who might be listening to this who are like, well, I think I might be seeing the kind of fraud that she's talking about, is stay at your company. Do not leave and then call me. That is the biggest mistake that people make. Now, I appreciate that some people have been terminated because they're too noisy. It's like Derek is in a role and Derek is like, wait a minute, you guys, we can't keep doing this. And they're like, Derek, just fire him because he's
causing trouble.
He's causing trouble. He's trying to get us to, to put all these measures in place, and we're not spending our money that way. So sometimes it just happens. You can't help it. The person has been terminated. The ideal whistleblower, it's really good for the not the person, not necessarily for me, but for them. If they come to me while they are still there. So a lot of people are thinking about leaving because the pressure on them is like killing them. Right. They're so stressed out by the time they get to me because they have been raising their hand. They know they are the experts and they know that this is not right. Whatever it is that's happening. And they're worried about their license and everyone's looking at them or they're ignoring them or they feel the pressure and then they quit and then they call and get an attorney. Well, the problem is if you haven't taken any documents with you to prove to me what you're saying, that's hard. That's more challenging for you because it's hard to just take somebody's word for it. If I have like somebody at the IT department of a big company and they're like, look, we have a lot of unresolved incidents. And I say, well, you're very entry level person there. And I'm not discounting what you're saying. I believe you, but do you have anything to show me to prove that? And if they say no, it's just what I saw when I was there. Okay, well, I have to dig a little deeper. Maybe I want to talk to somebody else who's at your company now, but that's hard. However, if
Okay.
you come to me and you're like, I have 1 week left at this company, then I say, try your best to stay in place, because let's talk about it while you're there. And maybe there are some examples. Don't download your whole laptop. You're going to get in all kinds of trouble for that. You shouldn't be
Yeah.
doing something like that, but I want to know what you're seeing while you're there. And then the other
Okay.
thing is, I just recently retained a whistleblower who's a physician, and she said to me she got bad legal advice because they told her because there was fraud happening, she had to quit her job, which she loved. And I said, no, you could have stayed in place and still filed this lawsuit. You don't need to quit your job. You're not doing anything wrong. You're just seeing it, but you don't need to quit your job that you really liked. And so she was very devastated when she heard that, because she said, well, I just, I have a friend of a friend who's an attorney, and he was like, oh, well, you have to quit your job right away. Well, no, you don't have to quit your job unless
Yeah, that's
you're
unfortunate.
committing fraud, well, but then you wouldn't be coming to me.
Right.
So you can stay in place. And some whistleblowers love their jobs. They don't want to leave their job. There's fraud happening, and that doesn't mean that they hate the whole company, right?
Right.
And my biggest example of that is Volkswagen. I was part of the monitorship team overseeing their guilty plea for environmental crimes. And it's an enormous corporation, Volkswagen. Hundreds of thousands of people work there. And as we went and interviewed people during the monitorship, many of them cried. They were like, I love this company. My father worked for this company. They didn't want to leave Volkswagen because it pled guilty to environmental crimes. They were ashamed, right?
Right.
But they loved their company. They don't have to leave their company. They don't have to leave their company. Things can get better where you work, and especially because you're stepping up and you're reporting frauds. And I'll tell you one example, Derek, because it sometimes surprises people. About 2 years ago, we got a settlement for a whistleblower. He was an excellent whistleblower. He loved his company, loved what he did, and he got a reward for blowing the whistle on his employer, and he still works there 2 years later. They know he's the whistleblower, and he still works there 2 years later, and he's had no problems whatsoever at the company, none at all. No one's even said a word to him about it.
Happy ending. I like that.
Happy ending. When he first came to me, he was like, if there's a resolution, do I have to quit? And I said, absolutely not. You do not have to quit your company. Do you like your company? Do you want to stay there? It's like, yeah, I started this company with the other founders.
Yeah.
I don't want to leave. I love what I do. It's a great job for me. And there's one piece of fraud that he was reporting. It wasn't the whole company. It was one piece of fraud that he reported, and the DOJ investigated, got a settlement, and he's there. He continues to work there. So some people put themselves in harm's way by trying to raise their hand and object way too loud without an attorney. That is, I guess, my biggest message to people is reach out and talk to an attorney before you get yourself fired or you make yourself a pariah at the company. You don't need to do that. Some people escalate the situation and make it worse for themselves instead of let me get an attorney to help me evaluate this. Let me stay cool, calm, and collected. I haven't done anything wrong. Why am I getting worked up? It's my employer that's done it, and I don't need to quit my job because there's fraud happening here. You don't
be strategic about it.
Some people want to quit their jobs, and that's okay too. Of course, some people are like, I'm done with this company. I've seen too much bad stuff. That's fine. I'm not going to tell you to keep your job. But a lot of people misunderstand that they have to leave their job. And they don't. If they like their company, they can stay. And we have quite a few clients that stay during the whole course of the investigation. And some of whom are going to, eventually, sometimes in the middle of the investigation, they find another job that they like and they go, and that's fine. Whatever they want.
Very insightful. So definitely anyone who's listening who may be in that position, got some good free legal advice for Renee, but I'll certainly put your contact information in the show notes and highly encourage them to reach out to you if they feel they're in that position. But Renee, I can't thank you enough for taking time out your busy day, for sharing your expertise and insights. It's such an intriguing topic. So like I said, I can go on for another 3-4 hours, but I know you got to get back to work. Me too.
I need to go to work on cybersecurity, right, Derek?
Exactly. But thanks again, Renee. And yeah, I appreciate it.
Thank you so much for having me. And I have my email address there, and folks can feel free if they think they want to run something by me to reach out. I always like talking to people. It's pretty much part of my daily routine.